The idea of separating the Attorney General from the cabinet. Yeah. I mean, I have been Deputy Attorney General and Solicitor General. I know the work of the Attorney General. It not only involves prosecution, it involves giving advice on transactions, legislation, and so forth, and on legal issues that arise. Now, any government would like to have an Attorney General in whom they have confidence.
Of course.
But I agree that the prosecution of criminal cases is something which could be separated. And so we try and establish a special prosecutor's office. Well, the jury is still out to see whether this necessarily stems the tide of corruption, or we haven't even had one prosecution, for a long time. So some of these things are so exaggerated. People say there should be a cap on ministerial appointments. Okay, you say the president shouldn't appoint X over X number of presidents, all right. In that case, I'll appoint presidential advisors. What do you do? This is exactly what happened when President Kufuor wanted to appoint a prime minister. They said, oh, it's not in the constitution. So she appointed Mrs. General Heze as chief advisor. Do the same thing. Or the president, there should be a cap on the appointment of Supreme Court judges. Mm. But we have a situation where our Supreme Court has a very wide jurisdiction, not only constitutional cases, but also, civil, criminal, and I was not in favor, but the access to the Supreme Court has been made so liberal, so they are really swamped by all sorts of cases. They don't only deal with constitutional cases, which are few and far between. Mm-hmm. So then if you put a cap, you are restricting the number of people who can dispose of other cases and so forth. These are things which you actually come to appreciate if you think of the Constitution in operation and not just a text.
Recently, there have been a lot of talks about certain aspects of the Constitution and its amendment. One particular aspect that has come up strongly is the Council of State.
Yes.
You said when you presented your proposal, the idea of a Council of State is that it should be more or less be turned into a second chamber.
Exactly.
That's what people advocate.
Yes.
Do you think you should go back to and look at that proposal?
Oh yes, we should go back and look at that proposal. We should look at the whole proposal of a second chamber. If you look at our constitutional history, the issue of a second chamber was fully discussed during the Kusi Committee proposals. And it was generally felt that, this was too elaborate. We were a small country, we couldn't afford to have to bicameral legislature and so forth and so on. But it's improved more and more in democratic countries that this is now a reasonable provision to make as some sort of check and balancing the legislature. And so, and also must have somebody which is less partisan and can look at that thing dispassionately. I look at the second chamber as one consisting of very distinguished personalities, chiefs, people, representative of non-governmental organizations and things of that sort, who can look at things dispassionately and say, Mr. President, I think this is far and no further, and whose debates are transparent and can be seen and heard at people. So this is a matter that we have to look at. But in all these matters, we must always think of the values. I was one of the first chairman of the Public Utilities Regulatory Commission. Okay. At that time, the minister was Ohinekena. Now, this was supposed to be, and it's still supposed to be, an independent institution which regulates tariffs, taking the interest of the utilities, the consumers, and the public at large, and so forth, and even the government. I got to know that before my appointment, Ohinekena went and consulted the other party At that time, Kandapa was sort of the person responsible for energy on the other side. And they had a consensus. That is the sort of value. For example, you're appointing an chairman of electoral commission. This is a national thing. If you had the value of promoting a national approach, you will consult. And it doesn't come, people are saying now saying that, oh, this must be stipulated by constitution. All right, so it will be stipulated by constitution, but these are some of the values. For example, the appointment of members of parliament to boards of statutory corporations. The only reason why they are done is that there's no constitutional prohibition, right there. But if you believe in the separation of powers, the idea that a member of the legislature should be part of a statutory corporation board, which is under a particular minister, which is part of the executive, the two things are inconsistent. So if you follow the value through, then you don't do this. These are some of the examples. When you talk of constitutional values, if you look at our original set of constitutional values, we derive them from Britain.
Okay.
And in Britain, it is not supposed to be anti-democratic or anti-constitutional to appoint a minister. In fact, all ministers are appointed from Parliament. Yes. So the tradition that we brought in there, it doesn't make this so terrible. But if you are saying that, you have a presidential system which more or less is following the American system and so on and so on, and you want that kind of thing, I agree with you that the British one does not purely follow the constitution, but we make a lot of noise about lack of parliamentary oversight. Exactly. And so we should be sensitive to those things which are undermined parliamentary oversight. There are other things too. One of the things that we did when we were doing the constitution was to provide for parliamentary review of international business, international economic transactions. Exactly. This was following our own experience. Now, before the 1992 Constitution, there was already provision for the approval of loans, international loans, even domestic loans, where government was a party, by Parliament. But people distinguish between loans and international business transactions. From my experience, that distinction doesn't make sense. Because if you have a project, you have a part, the financing component, and the other, the construction and other components, which are very, very interesting. The Balco. The Balco project, you had the financing component. We borrowed from various sources. But there was the construction of the smelter, the sale of the electric power by Balco to the government. So you can't say that only the loans will be approved, the rest will not be approved. So we provided for the approval of international loans, not only international loans, but international business and economic transactions, like the IMF, and so forth and so on. So now, when the Constitution came into effect, we used to have an interministerial committee known as the Public Agreement Review Committee. This is when I was Solicitor General and Deputy Secretary, with no agreement negotiated by any ministry, department, or governmental agency could go to cabinet or the ultimate council without approval by this committee. So that at the executive level, we looked at it very carefully.
Peer review.
Yes. When the Constitution came to pass, somebody said, oh, if we have parliamentary approval of it, it's not necessary for this executive mechanism to exist, which was very, very wrong, because the executive is the real place where you do the actual negotiation. And then when it came to parliamentary approval, sometimes you have a certificate of emergency 40 years out, yes. So that parliamentary overview, which is stipulated review, has never been properly implemented. And we cry about debts and so forth. Everything went through Parliament.
For instance, let me we've been complaining about our president being too powerful.
What?
We have an
Exactly.
overbearing
Exactly.
president.
Yes.
So, just opposing that with the values, are you suggesting that we can't do anything constitutional wise to curb that?
Okay, we can.
We need to stick to the values that you are talking about. And what sort of values?
Okay.
Yes.
All right. You have raised a very important thing. I agree with you that when you look at the constitutional text, presidential powers are wide. This derives from the fact that, when many of our proposals were rejected, such as this idea, the dichotomy between prime minister and president, they went back to 1979 Constitution, and some of these provisions we are decrying are all in 1979 Constitution. But here we are complaining that presidential powers are wide. My point is that subsequent to the 1992 Constitution, we are conferred more power on the president in two instances. I've given you one instance where, despite the fact that there's no stipulation in the Constitution which warrants the dissolution of boards of statutory corporations, the two parties in the Presidential Transition Act provided for the removal of all directors and anybody who was supposed to be politically appointed, all directors. So this was the part. Now, if you
point of correction, there was a Supreme Court case which
qualified that.
Yes, that
it qualified that only with respect to the chief executive.
The chief executives, okay.
So I was counsel number 2 in the Salah case.
Oh
yes.
Oh, okay.
Yes. I was Solicitor General then, and the Attorney General led me. And I keep saying that the Salah case was a typical case in which the government, the Supreme Court said that you can't dispose of public officers partly because of their political allegiance. Yes. But this is exactly what we are doing now. This is the norm. We come in and we say, oh, this one was appointed by this.
So it has already been established?
It has already been, yes. Okay. But it was established. So the Presidential Transition Act actually gave legislative force to this project, which started in the Fourth Republic. I remember in 2009, members being removed, the Bank of Ghana, the governors of not the governors, all the board members, and some could just take the matter to court, say this is not constitutional because we have a defined term, and so forth and so on and so on. So this is a case where the Constitution did not confer power on the president to remove these people. The Consultative Assembly, the Presidential Transition Act confers that power. By doing so, it widens the presidential power.
It has nothing to do with the Constitution.
It has nothing to do with the Constitution. Now he has to appoint all of the patronage. It's incredible. All, statutory corporations, statutory committees, and so forth and so on. Again, we are talking about the appointment of members of parliament to boards. That was not in the Constitution. There was a time, it's now changed, when by virtue of the interpretation of Article 108, it was felt by members of parliament, the interpretation was by a speaker, that no member of parliament could introduce a bill which had the slightest financial implication, even like buying a paper, until Speaker Okoye came and said this is a wrong interpretation. So if you do that, and you say that only bills can come which have the power, authority of the president, you are enhancing. So there are discrete areas where we have enhanced presidential power. And I don't know whether it's because we are, nationally obsequious or whatnot. But this is, so these are some of the values. If you really want to have checks and balances, then everybody must exercise their rights and powers granted to them, not only by the express words of the Constitution, but also by by virtue of the values which go
so
with that.
Nana, these values, you've put a lot of emphasis on these values.
Yeah.
Is this something that do we have to grow into it? Do we have to develop it? Do we have to agree?
Yes.
Or what do we have to do to
what do we have to do?
this sort of values
Yes.
into our... Yeah.
You know, if you look at the functions of the NCCE,
Exactly.
The National Commission for Civic Education, it expressly stipulates that that commission should educate the public on the principles of the Constitution. And these things have to be inculcated. If you had a series of regimes which are not constitutional, not imbued with the human rights tradition, we need to be inculcated. You know, I used to be a member of the Judicial Council, and we used to interview prospective judges. And it was one of our special functions to make sure that judges who, according to the Constitution, are to implement human rights provisions were aware. I won't tell you what happened with that is under judicial oath of secrecy. But at least we alerted them to that. Even judges were alerted to that. Yeah, some people went to law school when there was no constitution.
Exactly.
You know, what is meant by human rights? What are the limitations of permissible limitations of human rights? The clawback provisions in the Constitution dealing with human rights. All these are very elaborately discussed in other jurisdictions, such as the US, India, the European Court of Human Rights, and so forth. They have to be studied. So that if we do, and we have to have public bodies and so forth, maybe non-governmental organizations and so forth, which are interested in these, so that you are not taken by surprise when something happens. Yes, they have to be inculcated. Most certainly, they have to be inculcated if we want to sustain them. Yeah.
Nana, I'm coming with this, okay. Nana, about the constitutional amendment, I will come back to that, but about the constitutional amendment, you've
let me make one point about the constitutional amendment. One of my remarks that I've been making is that we have been reviewing the Constitution for 30 years. You know, there was a whole Constitutional Review Commission. And sometimes we have to consider why it is that none of these reforms have taken place. And it is my view, my very, very humble view, that the two major political parties are not really committed to a real constitution, because they have to take the lead in the constitutional reform. The amendment procedures presuppose their leadership and involvement. So you can have civil society organizations and academics and others talking about review and review, but if they're not taken up at a political level, what happened to the reports?
There was one set up by former President Mills.
I know, it was set up, but what happened to the results? I mean, my friend, Professor Fiajo was the chairman, and Tukuba was the secretary. It went on for 2 years. They produced a very voluminous report. What happened to it? And I can tell you that many, many organizations have done a thorough review of the Constitution. The IEA is doing it right now. Previously, it did it before when the winner takes all. It did it. The Ghana Academy of Arts and Sciences has done it. I know that GIMPA Law Faculty is going to do it next month or so. And now even the NCC, which is supposed to actually educate the public on constitutional principles, wants to do a review. It's like they're collating the views of people. And we spent the whole 2 years on that constitutional review. So what became of it? So when people talk of it, we must also ask, how come that the constitutional review, which has been done, has not been translated into action? But I was interrupting you. So
no, I'm interested in that point. So what you're saying is that unless or except these two political parties.
Yes, and my famous statement is that those who are interested in constitutional review do not have the power. Those who have the will to review the Constitution do not have the power. And those who have the power do not have the will, do not have the will to do it.